So before I introduce the patent law reform panel, I just want to make one announcement, which may be of interest to at least some of the folks here. On April 17th at 4 p.m. At the Bryan Research Building here at Duke in room 103, Chris Holman, who's a professor at UMKC Law School, will be delivering a talk based on a very extensive empirical study he's done of all gene patent litigation. The talk is entitled Gene Patents in Litigation, Past, Present, and Future. I know that's a lot of information quickly. If you have any questions about it, feel free to send me an email at ry@law.duke.edu, and I'll give you the information. But it occurs to me that many of you might be interested in this very comprehensive empirical study. Okay, so we've already broached the very contentious subject of patent law reform in its many different venues, whether it takes place at the Supreme Court, which has been essentially engaging in extreme amounts of reform in the last few years. At the PTO, we've already talked about whether the PTO has done a particularly good job in thinking about some of the reforms that it's put forward. And then obviously in Congress as well, Professor Thomas has provided us with a really comprehensive overview of all of those venues. The panel today is very well positioned to address different aspects of these areas in which different institutions have been engaging in legal reform. And they are positioned not only to do so from the perspective of patent law, because they're all well-renowned patent lawyers, extremely well-renowned patent lawyers, but also because they know the perspectives of some of the industry actors that have significant interests and probably, I think it's fair to say, very different positions on certain aspects of patent law reform. In particular, information technology and electronics versus, to put it simplistically, the biopharmaceutical industry. And that is an aspect of the patent law reform process, whether done in the courts or the legislature or the administrative agency, that will be highlighted in this panel, I think, very nicely. We have, as I indicated, four extremely well-qualified people to speak on these subjects. We will begin with Mr. Bruce Wieder, who is a partner at Down Lonas, one of the sponsors of this conference. He is a member of the Media and Information Technologies Practice Group and specializes in patent litigation at both the trial and appellate levels. And he also does a lot of patent licensing and settlement work. He has represented clients before the Federal Circuit, before federal district courts, and before the USPTO. Prior to joining Dow Lonas, Mr. Reeder was a partner at Burns Doan, and he was also a law clerk for the Honorable Judge Plager, who's already been mentioned as a member of the Federal Circuit, who actually came from academia. Mr. Reeder, as Professor Thomas has pointed out, is an adjunct professor at Georgetown. I'm going to go ahead and introduce all four of the panelists so that we won't have the problem of my interrupting the continuous flow of conversation, of substantive conversation. So Mr. Vida will speak first. He will be followed by Mr. Jeffrey Kushan. Am I pronouncing that correctly? Is it Kushan? Who is a partner at Sidley Austin in Washington, D.C. He is, in fact, the practice group chair for the patent group in the firm's D.C. office. He focuses his work on Hatch-Waxman patent litigation, patent appeals, and also complex patent administrative proceedings. In 2003, he was named one of the top 45 lawyers in the United States under the age of 45 by American Lawyer magazine. Before entering private practices, probably became clear from our exchange earlier, he worked in the government, including the PTO, for over a decade. He began his career at the PTO as a patent examiner and moved on to do a lot of work in the Office of Legislative and International Affairs, and did work on, and I think it's fair to say, some well-regarded PTO actions, the PTO examination guidelines for software inventions, the PTO utility examination guidelines for biotech and pharmaceuticals. From 1995 to 1997, he served in the office of the USTR in Geneva, so he's had a lot of international experience as well. He's testified numerous times before Congress on questions of patent law reform, and he is a member of the George Washington University Intellectual Property Advisory Board. Next, we'll have a little bit out of order from the order that's listed on the panel, but it will be very clear to you that the progression will work nicely this way. Mr. Andrew Spence, who is a partner at Alston & Bird, another sponsor of our conference. His practice focuses on patent solicitation in the electrical, computer software, and business method arts. So he brings that kind of IT focus to our panel. He's drafted and prosecuted applications in all of those areas, and he counsels clients on a variety of intellectual property matters more generally, including infringement, validity, and enforceability. He is a member of the AIPLA, which has been mentioned several times already, and he writes on patent law matters, particularly in the area of business method patents. He is also a member of the intellectual property law section of the North Carolina Bar Association, which is an active section that some of us have had the opportunity to interact with. And then finally, last but certainly not least, replacing Charles Calkins, who unfortunately could not be here today, is Cynthia Rothschild, who is a partner at Kilpatrick Stockton, where she practices intellectual property law. Dr. Rothschild began as a research assistant professor at Wake Forest University Law Medical School, where she developed a highly sensitive assay for detection of genetic changes associated with cancer. As a member of the patent group at Kilpatrick Stockton, she's worked with a variety of companies and universities to develop their IP portfolios in pharmaceuticals, chemical compounds, and biotechnology, and also counsels clients on the development of new technologies. She is a member of the North Carolina Bar IP section and chaired the IP section's Continuing Legal Education Committee from 2006 to 2007. We're delighted to have all of our panelists here, and we will proceed, as I said, sequentially without my interruptions. They will each deliver talks of between 15 to 20 minutes, and subsequent to that, we will have moderated panel discussion and question and answer. And for that moderated panel discussion, Professor Thomas will join us. So we'll have a truly, I think, very engaged set of deliberations on the questions of patent law reform. So, Mr. Reader.
Good morning. Thank you for inviting me, and it is a pleasure to be here. I'm going to try to cram in way more information than I should into this relatively short period of time. And I guess as a cautionary tale, I'll tell you the story of the inventor of the vacuum bottle, the thermos, who decided to try to put in as few words as possible what his invention would do. And he said, it keeps hot things hot and it keeps cold things cold. He sold the first one. It was returned the next day. The person said it didn't work. He said, well, what did you put in it? He said, 2 popsicles and a cup of coffee. That's going to be the problem here. We're going to cram a lot of information in, and you may get sort of the wrong impression of a few things. So hopefully we'll use the panel to straighten that out. One thing I do want to make clear is the opinions that I give here are my opinions. They're not the opinions of Dow Lonas. They're not the opinions of Georgetown University. They're mine. So I take all the blame, and if there's any credit, you can give it to the people who taught me at one point in my career. As Professor Thomas pointed out, a lot of this had its origins in the Federal Trade Commission 2003 report on promoting innovation and this STEP report, the report the National Academies put out. Everybody had their own suggestions. So there was some overlap. And the 4 points of overlap were that we ought to revise our patent laws to provide a procedure to allow third parties to participate in some sort of post-grant review. We need to reinvigorate the standard for obviousness. We need to reduce the issuance of patents on inventions that would have been obvious. We need to provide better funding to the PTO. This may be, and we'll talk about this in a little more detail, this may be the one thing that everybody seemed to agree on from all sides of the debate. And we also need to tighten the standard for willfulness to make it more difficult to prove that an infringer acted willfully. There's this notion that this willfulness issue has been abused well beyond what anyone would have thought. So let's start in post-grant opposition. Both the House and Senate bills propose post-grant opposition proceedings. Unlike the current inter-parties reexamination proceeding, and that for those of you who weren't going through the details, you may say, well, wait, what do you mean post-grant opposition? We have it. We have reexamination. We have inter-parties reexamination now. Probably the most fundamental difference is that this procedure would allow the testimony of witnesses. In fact, the Senate bill says if you get this in place, you don't need inter-parties reexamination. What about nuisance actions? And this has been the debate about all these post-grant proceedings, whether they were reexamination or otherwise. How do you keep nuisance actions away? And current law talks about you need to have a substantial new question of patentability. That's the threshold to get into the PTO. Both of these bills have language that raises that substantial question of patentability. For current inter-parties reexamination, there's another big block for a lot of people, which is this language. If you are the third-party requester in an inter-parties reexamination, in a subsequent litigation, you are stopped from raising an invalidity issue based on any ground which the third-party requester raised or could have raised. And that's the key, or could have raised. So a lot of folks who might otherwise go ahead with inter-parties reexamination say, wait a minute, I don't think I want to give up my opportunity to raise things in trial, so I think I'll just skip inter-parties. Proposed post-grant opposition proceedings create an estoppel against the opposer only for any ground which is raised during the proceeding. All right, now let's sit on the other side of the fence for a second. You're the patentee. If this thing passes, what limits serial opposition proceedings? What limits the ability of somebody else to tie up your patent in post-grant opposition pretty much till it expires? And the answer to that, the bill proposes 12-month window in which to bring in opposition. Patents granted, 12 months. In Europe, you have 9 months. 9 months, 12 months, that's, but the basic idea of putting a time limit on it. One of the latecomers to the party of patent reform was the inclusion of a second window. The Senate bill says, well, you only get a second window where the opposer shows a substantial reason to believe that the continued existence of the challenged claim causes or is likely to cause petitioner significant economic harm. Who else is going to oppose it? Guy going down the street, I just don't like the idea of that patent. I think I'll go spend my money and challenge it. Highly unlikely. So it essentially opens up the second window to almost any time. The House bill has a provision that says only get a second window if the patent owner consents. This is all part of the stuff between the House and Senate bills that are going to have to get reconciled at some point. Second thing that the FTC and the National Academies agreed on, we need to reinvigorate the standard for obviousness. The bills don't really go there. And why not? Because the courts already took care of that. KSR. There is one thing that just sort of, and again, my opinions, not that of the law firm, not that of Georgetown, that gets my attention. Currently, Section 102 of the patent law says, a person shall be entitled to a patent unless. If you file your application, you are, according to 102, entitled to a patent unless, and then there is the list of things. Under proposed 102, a patent for a claimed invention may not be obtained if. You tell me, does that weaken any entitlement to a patent? You tell me, does it say the list of statutory reasons to not grant a patent is no longer the exclusive list? I think what we have is an indication of how Congress is looking at patents these days, a much more jaundiced eye at the whole thing. Providing additional funding to the PTO. The PTO up through 2005 would collect its fees, they would go into the general treasury, they would then be allocated back some portion of them. There was what was affectionately referred to as fee diversion. In other words, the treasury took money and didn't give it back. Everybody seemed to say, we've got to have a stable and adequate source of funding for the PTO. The PTO raises its rates for applications, and yet they don't see any additional monies as a result of that. It goes into the general treasury. What has happened since 2005 is they effectively have stopped diverting, and up through proposal for fiscal year 2009, there will also not be diversion. The Senate bill proposes allowing the PTO to keep all the fees collected. The House bill, on the other hand, does not. I think that's one of the strangest things about this. This is a provision that everyone thought was important. The White House, by the way, even came out against having a provision to avoid fee diversion because they said that will reduce our oversight capability to the PTO. Other thing requested is tightening the standard for willfulness. Well, the Federal Circuit's en banc decision in Seagate created this new test for willful infringement, which, for those of you who didn't catch it, creates this objectively high likelihood test as opposed to the old subjective test, and adds a second part also related to this objectively high likelihood test. Now, the current bills that are pending were written before Seagate. So, in fact, the bills would undo what Seagate did. I don't think that's what anybody intends. I suspect that will be fixed. There is talk about fixing that already, although nothing in writing that I have seen. And so we'll just sort of skip over what the current bill is proposing to do, because I think that's just going to go by the wayside. Those are the four provisions that the FTC and the National Academies agreed on. Post-grant opposition, effectively replacing then inter-parties reexamination. Reinvigorating obviousness, not doing that because KSR took care of that. Provide additional funding to the PTO, which they're not doing, although obviously with any appropriations bill they could decide not to divert, which they have been doing since 2005, but they're refusing at this point to put it into the reform. And tightening willfulness, which, unless they're careful, they're going to undo what Seagate did. One might argue, if that's what everybody's agreed on, why are we having the reform bill? But putting that little instant aside, additional proposed changes. Abandoning first to invent for first inventor to file. Now, I know people argue that this is helpful for harmonization, but what it does, quite frankly, it puts a premium on the race to the patent office. And if you're Elisha Gray and the other guy's Alexander Graham Bell, you're a little ticked off that Bell got there a couple hours before you did, because it made, I don't know, a little more money for Bell than it did for Gray. The other thing, by the way, for those of you who are thinking of becoming patent practitioners, patent prosecutors, and you decide it's a real nice Friday afternoon, I'm going to take the afternoon off, and the other guy gets there with his application a day before you get your client's application there. Today, you probably are going to win ultimately in the interference proceeding because you're going to establish he was the first to invent and first to reduce to practice. You will lose now because you weren't the first one to the patent office. I think the practitioners' malpractice insurance premiums are going to go through the roof. Prior user rights. There's much talk about adding prior user rights, but it has effectively been removed from the patent bills. To the extent we have prior user rights now, they're for business method patents, and that's, I think, where they're going to stay unless somebody changes this bill again. This is probably the big hot button issue. This is the thing that has certainly gotten Chief Judge Michel's attention. Under current law, a patentee shall be awarded damages shall be, not might be, could be, you ought to think about, shall be awarded damages adequate to compensate for the infringement, but in no event less than a reasonable royalty. Now, how do you calculate that? Well, for those of you who have taken enough IP classes, you say to yourself immediately, the Georgia-Pacific factors. We're not going to go over the Georgia-Pacific factors. That's a 2-hour lecture. The proposed bill say they are going to ensure that a reasonable, and follow along with this, because if you play this with the home game, it's just a killer. The proposed bills ensure that a reasonable royalty is applied only to the portion of the economic value of the infringing product or process properly attributable to the claimed invention's specific contribution over the prior art. I hear you say, huh? What does that mean? How do you figure this out? And frankly, you're not alone if that's your concern. Chief Judge Michel has written to Congress stating that the proposed change in this statute was going to add uncertainty to the law and reduce the likelihood of settlement of cases. And one of the things to think about, by the way, from and I don't mean to speak for the chief, but one of the things that I'm sure is his concern is the administration of the court and the process that goes on. And he says this raises the possibility of increased lengths of damages trial and increased associated trial costs. He's not alone. On February 4th, the White House, in the form of the Commerce Department, sent a letter to Senator Leahy saying it opposes the apportionment provision. And he says, at a time when we are actively encouraging foreign trade partners to strengthen their IP protection and enforcement, this sends the opposite signal, that we intend to weaken aspects of our current law and deter infringement. And you think about what Professor Thomas said earlier. In the 70s, there was this push for a more robust patent system, and now the White House is saying, you do this, you're going to weaken our system. We talked earlier about venue, and the current venue statutes, let there be no doubt, they allow forum shopping. What the Federal Courts Improvement Act of 1982 did was it said there's not going to be forum shopping for purposes of what court of appeals we're going to go to. You're all going to go to the same court of appeals, the Federal Circuit. That doesn't mean there's not going to be forum shopping at the district court level. Current statute says any action for infringement may be brought in the judicial district where the defendant resides. And a defendant that's in a corporation resides wherever it's subject to personal jurisdiction. And that's been the problem. This was the V.E. Holding case from 1990. And the problem with that is it says if you are a corporation, and let's think about the funny case of this, you're a Delaware corporation, which means you're incorporated in Delaware, your corporate offices are in Delaware, you're suing a Delaware corporation, its corporate offices are in Delaware, but it turns out the defendant sells some of its products in Houston, and lo and behold, you're both in the Eastern District of Texas. You think that sounds kind of odd. So the proposed revisions would limit venue with respect to corporate entities to where the defendant has its principal place of business or is incorporated, or where the defendant has committed a substantial portion of the acts and has a regular and established physical facility that the defendant controls. This is a significant change. You have to think, by the way, if you think back to the last Congress, Darrell Iss's bill, where he said, hey, you know what we ought to do is we ought to get some judges who are sort of specially trained to deal with patent cases, because patent cases are sort of an odd and time-consuming type of litigation. And let's see if we can sort of concentrate patent cases with these well-trained judges. And then we have a provision here that says, tell you what, let's not concentrate patent cases. Let's limit where they can be brought. So there seems to be a bit of a schizophrenia with respect to the venue provision. There's an additional provision in the House bill that allows or creates venue, and there is another provision that allows, for if you're a small inventor and you're the plaintiff, venue would be proper where you reside as well, which is an interesting twist in venue statutes concerned with where the plaintiff resides as opposed to just the defendant. Interlocutory appeals. This is another proposed change in the patent reform. One of the problems that people talk about now is that the Federal Circuit, because they take claim construction as a matter of de novo review, they get a great deal of cases that get reversed, they reverse a great number of cases, and what we ought to do, rather than have the entire trial on the case, we ought to get the patent claim construction issue up on interlocutory appeal. A very hot button issue, again, for the chief judge because of, among other things, certainly management of his docket. But as Chief Judge Michel said at the speech in the end of January, he said, currently 70 to 80% of all patent appeals come from summary judgment rulings, not trials. So they are effectively pre-trial interlocutory claim constructions, and we don't need this change. He also cautioned, he said, you do this, and because of the impact of additional filings, you can expect delays of essentially an additional year over what you have now, from roughly 1 year to 2 years. There are a group of people out there, and just mention that this is not patent reform necessarily, that is, this is not part of any bill, but it's been suggested that the high reversal rate ought to be reduced if, in fact, the Federal Circuit reconsiders its standard of de novo review for claim construction. And for those of you that have been reading Federal Circuit cases lately, you've seen several judges commenting on that. I think probably Judge Mayer may be the most outspoken on the court revisiting this whole issue. Publication of patent applications after 18 months. That's the current law, but there is an exception. We'd like to get the exception out, said some of the patent reform folks. The proposed Senate bill removes the exception. Strangely, and I have, actually in my little notes I wrote the word, well, I wrote a word that I can't say publicly. I shouldn't write things like that in my notes. Strangely, the House bill will modify this language, essentially allowing secrecy for 2 to 3 years, because it has a provision that says you can delay publication at least through 3 months after a second office action. I don't really have an answer to why that's in there. It is, and it seems to be the antithesis of this early publication idea. Prior art search and relevancy reports, another wonderfully hot issue. Right now, an inventor is required to disclose to the PTO all information material to patentability known to the inventor. No requirement to undertake a search. What you know you have to disclose. You don't have to go off and discover. The proposed bill changes this. The House bill says the PTO may require this. The Senate bill says it shall require that, excuse me, one step too far, shall require a search report and a relevancy analysis. We can talk during the panel discussion a little bit more about the problems with something like this. The potential for inequitable conduct claims is just overwhelming. Speaking of inequitable conduct, under current case law, if you fail to disclose a material reference with the intent to deceive or mislead, your patent application and related patents may be held unenforceable. This is what you want. You've got an ex parte proceeding. You want the people who come into the patent office to be forthright with the examiner. You don't want people hiding things and lying to the examiner. So you have a very draconian position. If you withhold a material piece of prior art with the intent to deceive, your patent will be held unenforceable. The proposed bill, oddly, will weaken the penalty. Instead, the penalty could be holding one or more of the claims unenforceable. So if you imagine, if you will, I hold back a prior art reference that would have invalidated claims 1 and 2, and what's my penalty? You may only lose claims 1 and 2. Doesn't seem to be a penalty. Limit the patent holder's remedy to a reasonable royalty. Currently, you don't get your patent is unenforceable. You still get a reasonable royalty. Or maybe hold the patent unenforceable. Strangely, only the House bill would add the remedy of holding claims of a related patent unenforceable, suggesting at least that the current penalty that we may go after your related patents, that is, infect your inequitable conduct infects your related patents, not clear that that would happen if the Senate version was passed. I know I've gone on way too long. I apologize. Elimination of the best mode defense. Under current law, if you fail to disclose the best mode for practicing certain claims, those claims are invalid. An examiner rarely knows if the best mode has been disclosed. It usually comes up, if at all, in the context of a defense to litigation, and this bill would eliminate that as a defense to litigation. Essentially writing best mode, I would tell you, out of the law for all practical purposes. The Senate bill, on the other hand, is silent on this fact. There's been a bit of discussion already about granting the PTO authority to promulgate substantive rules of patent law. There is a debate. The House says that would be a great idea. The Senate says we're not so confident of the PTO. Tell you what, you can set your own fees, but that's as far as we're willing to go. The White House, by the way, is against this provision. My very final comments here, what's missing? To me, they don't address a fundamental problem. How does a well-meaning manufacturer or developer bring a product or service to market without infringing the patent rights of others? This is what you've probably heard this expression, the patent thicket. How do you navigate this thing? The costs, in my experience, can effectively exclude small players from the market. And I've seen some folks with what I think are some potentially very interesting products say, to heck with this, it's just not worth it. And so the marketplace does, in fact, lose those. Current patent reforms, in a nutshell, reduce damages a patentee can obtain for infringement of her patent and reduce the likelihood of an injunction. And while this can aid some manufacturers who are in the business now, it's at the expense of inventors. And to me, again, personal opinion, maybe we ought to think about whether that's how we really want to reweigh this. And thank you. Well, I guess we'll take questions with the panel.
We'll take questions after all the presenters have spoken and with Jay Thomas joining us. So next we have Jeff.
Thank you for inviting me to come down and talk about patent reform. It's a topic I've been working on for the last 15 or 20 years. And this latest round has been very entertaining. I also want to thank Bruce for doing a very nice setup for my talk so I can streamline and home in on a couple issues. I thought his overview of the variables in the bill was very nice, and he hit all the major issues. Forward. So I also thank Jay for setting up this talk as well, because he's already pointed to some of the drivers for the patent reform effort that's underway now. One thing that I think I want to emphasize that was a common theme for a lot of the reform calls was the desire to create greater clarity in the patent law environment. And it's important to appreciate what that means. When we don't know what the outcome of litigation is when we look at a patent before we're in litigation, then that creates an impetus to go into litigation if you're the infringer, because your landscape is somehow going to be improved if you kill that patent. And if you can sit back and say, well, there's 10 or 15 things that we can't really predict that might kill the patent, that has a perverse effect of inducing litigation to try to see if you can kind of win on a lottery-like theory of getting past that patent. There are a lot of things in the patent law that cause uncertainty. There are imprecise standards of what prior art is. There's imprecise standards on obviousness. There's imprecise standards on what you have to describe to enable and describe an invention and satisfy 112. Best mode, in all due respect to Bruce, best mode is essentially a futile and nightmarish standard. What did the patent, and ultimately it's worthless because the patent owner, what the patent applicant knew when they filed the patent application rarely has any relevance in the commercial world when they actually launch a product 7 or 8 years later. It's this subjective standard that just creates a lot of uncertainty. Inequitable conduct is probably the worst of these in the area because it's entirely subjective. What did you say to the patent examiner, or what did you not say? You know, if you've ever seen a deposition of a witness, when they're stressed out, they say things that make beautiful inequitable conduct cases, and it has nothing to do with the real world or what actually happened. But there are these variables in the landscape of patent law that were the target of fixing the patent law, the things that cause confusion. The more confusion there is, standards, outcomes, and litigation, the worse the patent system functions. The other big part of the equation is in the areas of getting injunctions, getting damages, figuring out what the damage liability is going to be, because that's the other variable that has a big distorting effect on negotiations between a patent owner and a patent infringer. And then, kind of interesting from my historical perspective, in the 90s, we all obsessed about, switching over to first to file, that's such the huge controversial issue. We can never really navigate that controversy. It's done. Nobody's even talking about it. And it's interesting from a perspective I have that the thing that paralyzed patent reform and international harmonization for about 15, 20, maybe 30 years is essentially not even the focus of controversy in the bill. I'll say that maybe relative controversy. Courts have obviously cleaned up a lot of stuff, which is why you see a somewhat leaner patent bill. And again, Jay's already hit on a few of these. You saw my partner, Carter Phillips, or maybe he was around here yesterday. He argued the eBay case. And, you know, it was an interesting time for me because I was up on the Hill telling him injunctions are crucial for the pharmaceutical industry while he's taking on that case. But that's the fun of law firm life. Willful infringement. Look, we can have different opinions, especially in front of Congress. Willful infringement is kind of become, well, I wouldn't say it's a non-issue yet, but it's soon to become a non-issue with the Seagate solution. And of course, obviousness addresses a lot of the concerns that was, captured in that NAS and FTC work. Bruce has already kind of skimmed through these. I'll just ignore them. And I'll home in on kind of the two drivers of the patent law reform debate right now. The first driver is damages, and I'll give you a foreshadowing. The second driver is inequitable conduct. The tech companies meaning the people who make Windows, there's one of them. There are the people who make routers, Cisco, the people who make the chips in the computers, Intel. Wait, there's only one per industry. It's interesting. All those folks want to change the dynamic of damages because what they face is a kind of a perversion of a particular area of the damages law. Now, this, as Bruce said, none of you will be subjected to the 15 factors in the Georgia-Pacific case. I will just point out that the Georgia-Pacific case has 15 factors because there's about 1 billion combinations between patents, their claims, and infringing products that you might encounter in an infringing situation that leads to a lot of different types of damages considerations. And so what you see in the Georgia-Pacific standards is a feeble attempt of the court to say, depending on what kind of situation you're in between the patent and the infringing product, try this concept out to figure out how much you should pay the patent owner. And so part of the complexity of the landscape of damages law is inherent to the fact that you've got different relationships between patent claims and infringing products. Now, there are some useful insights from the Georgia-Pacific factors, and a lot of people in the debates have recognized that a lot of that stuff is okay. The common law that's evolved provides a generally good answer in standards for a lot of situations that you encounter in a patent damages case. And so the real stress point has really focused in on where you have a high value product and you have what is perceived to be a trivial improvement patent using the total value of that high value product to figure out what the damages award is going to be. Now, there's two versions of this. One is where your patent is little, your patent claims are narrow. That was the conventional entire market rule where you say, I have a patent on this little tiny component. I don't have a patent on the thing it's in. I don't have a patent on the car. I have a patent only on the windshield wiper. But, court, you need to give me the base value of the car to figure out what my invention's worth, because, that windshield wiper makes the car. When people go out car shopping, they buy the car because of the windshield wiper. Now, that may not sound right in the case of a car, but a lot of other products, you will find this little tiny piece that's kind of been rolled up into a package of other parts, but that's the thing that really drives the sales of that thing. It may be an old device that is improved significantly and lets the patent owner, capture a lot more money by inclusion of this relatively minor or small piece of it. But where the patent claims are tied only to that little piece, they've got to fight their way out and expand the base of the damages award to capture the larger item. That's not the problem that the manufacturers are yelling about. They're yelling about the problem that says a patent claim issues that claims a computer comprising, and then they love this one, a blinking blue LED. And you could take the example of Windows saying an operating system comprising, an optional MP3 compression algorithm that doesn't actually ever get invoked. So in those kind of settings, the big companies say, wait a minute, why should we hand a jury a number like $16 billion, which is going to poison their minds like you can't even believe, along with a list of 15 other standards that they don't even understand, and say, that product infringes this patent, it makes $16 billion, figure out how much to give the patent owner. That's essentially the nightmare they face. They basically have courts who aren't filtering the translation of what the value of the patent and invention is, and then using the kind of exaggerated foundation of a large number to cause a big number coming out at the other end. That's their concern. And that is made possible by kind of this weird intersection of the case of the claims covering the whole product, which lets them essentially bypass that whole fight of expanding the base. The first instance of EMV where you're saying my claim is only limited to a piece. They're saying my claim is the whole thing. So let's start there. And then let's try to figure out why you should shrink it down. And that is a really hard thing to do, because as soon as you start shrinking down the patent and invention reflected by what is claimed, you start to do this somewhat artificial exercise of figuring out what made this claim patentable in the first instance. And that's really hard. Why is that hard? Because there are these wonderful old cases by judges who are not sitting on the federal circuit, so it's not contemptuous just because they said it, but back in the old days when the old Supreme Court justices said this, virtually every invention is a combination of old elements. And so the standard can't be simply that this is something which combines old elements, because that's pretty much every invention. So there needs to be some kind of a process of filtering, and what you end up with is essentially an impenetrable problem. The thing that I've seen in these debates is there is an inherent conflict that different industries will have valuable products that are made up of combinations, and other industries will have valuable products made out of combinations where the invention really isn't valuable. And it's kind of that kind of common fact pattern in legal standard that is landing on both types of products that creates the stress between the industries. So with an intractable problem, what is the only thing that comes out that seems to be workable at this point? Well, one thing that everybody seems to agree on is that all the courts should do a much better job of filtering the evidence going to the juries. And that's, basically this notion of a gatekeeper function where you will say, Judge, you really have to step up and translate this case into those Georgia-Pacific factors and those bits of evidence that relate to those Georgia-Pacific factors that match this case. Because part of the problem in a lot of cases is that the judges say, I'm going to get it reversed by the federal circuit anyway. It's all coming in. All the evidence is going in. I'm not going to stop a party from putting on a story, a theory, or any evidence relating to the damages determination, so it's all going in. And then you hand off this massive pile of information to a jury, and they go, I'm not a lawyer. I'm thankfully not even a patent lawyer. I'm not sure what this invention is. All I know, the only thing I remember is $16 billion and they infringe. Well, 1% sounds fair. It's just a little part. So that's the dynamic that you see in the tension. So the court's doing something to say, wait a minute, here's the factors, here's the perspective you should use, and filtering the evidence is actually a huge win for the tech companies. Now, lest you believe I'm actually here for the tech companies, I've just listened to them more than anybody should probably ever have to in their lifetime. That's their problem. I represent a life sciences company, and it's interesting. The life sciences industries have very high-value products that are the product of often modest improvements over the art. So stabilizing a protein that was previously unusable because you could never administer it to somebody, well, if the invention is adding an old salt to that composition and that produces a billion-dollar-a-year drug, I don't want to get paid for salt. $20 a ton isn't really what I was looking for in my invention. So there's a sensitivity to making sure that you don't diminish the small inventions that have a huge economic impact and all squeeze them through some kind of a common metric. Now, the inequitable conduct variable is the other part of this equation, and I've become kind of biggest fan of inequitable conduct, well, changing, or my first choice would be to delete one word from the statute, which is unenforceable. Why? Well, the inequitable conduct doctrine is a wonderful thing for defendants. It's based on deposition testimony of your opponent's witnesses. It's a lottery. Basically, here I am facing a valid patent. Nobody's saying this patent's not good. It's a valid patent. It's protecting a valuable product. So, novel, non-obvious, great. All the criticism of the patent system doesn't apply here. This patent was properly issued because on the merits, it's protecting a patentable invention. And so, despite that, I wipe out the entire patent. Every claim in the patent is dead if I win on this defense. So the fact that I might have licensed claim 1 to Amgen and claim 2 to Genentech and claim 3 to Biogen doesn't matter. It's all toast. The whole patent's dead. So what does that do? It makes the patent owner extremely sensitive to not being in litigation with a potential risk of inequitable conduct. And that skews the litigation to a degree you cannot even quantify. And it's most noticeable in high-value patent situations, obviously. But what has compounded the problem is that the proofs are essentially malleable, right? There was a case recently that said that the wrong fee being paid was material information that could have affected the issuance of the patent. This is the $300 versus $750 payment you make when you file your patent application. I paid the wrong fee because I had licensed my patent to a guy who had 500 employees in his company. I don't even think most patent lawyers knew that changed the fee obligations for small entity versus large entity. But the kind of the freedom that you have seen in the case law in the inequitable conduct area to concoct what is now material, coupled with the standard that says, well, if it's material, well, you must have intended to do it, so you bypass what originally was a separate proof, and all of a sudden you see a lot more cases surviving the first and second waves of your case in the litigation. And if you're sitting there going to trial and you survive summary judgment attacks on trying to get rid of inequitable conduct, you see a very different equation in settling that case than if you if you didn't have a doctrine like this. So, what's wrong with where we are now? Well, the patent bills in both House and Senate didn't try to change the law. What they tried to do is capture what they thought the law was, and through the use of somewhat more generalized language, what they're doing is either compounding problems or not solving their underlying problem, which is first, the lottery-like effect of the defense. And in this aspect, you see that one element that was included was kind of a variable sanction. That notion is a good start, but it's still not telling the court which sanction to impose in which circumstance. Remember, this is a fraud-based doctrine. Now, we all know there could be little fraud, there could be errors of omission, and there could be the truly evil behavior. Doesn't matter which flavor it is, the patent dies. That's the current law. In the bills, it's basically, well, pick one. Let the defendant pick which remedy they want. Oh, I want to kill the whole patent. I don't want that reasonable royalty thing. So you need some kind of a filtering exercise that says, impose a sanction only when you really should, try to scale it to the conduct that's been proven, and most importantly, tighten down these standards so that not every conceivable theory can be thrown at the patent for inequitable conduct. And I'll just point out one thing. The inequitable conduct doctrine arose when we really did have a secret examination process. No publication, nobody knew what was going on, and so there was an exaggerated need. You needed an exaggerated sanction to make sure that people were just coughing up everything they could during that secret examination process. Right now, everybody knows exactly what's happening on a real-time basis on every patent application through publication, except for the little guys that are exempted by that thing that Bruce pointed out on publication. That changed dynamic in the environment, and then when you throw onto that the post-grant opposition and all the other ways of getting the patent back to the patent office to get knocked out without litigation, that changes very much the justification for inequitable conduct, and particularly the severity of the sanctions. So this is an area that has to be significantly improved in both houses to get this whole package done. This is one thing that the life sciences side of the equation of debate has really made as a major issue, and you'll see that as a necessary resolution. So I'll just wrap up real quick. We all saw that TV show in the morning when we were kids, Bill on Capitol Hill. What's not really shown in that movie is the cloture, which is a hard word for little kids. The Senate has a wonderful process that says, if I don't like the bill, it's not getting onto the floor for a vote. If it doesn't get onto the floor for a vote, you can't pass it. To override cloture, which you have to basically have 61 senators say, I don't care, we're moving it to the floor. Right now, more than 40 senators have said, not ready to do that to my friends. So as a consequence, the bill is in the Senate paralyzed, and if it can't get to the floor, it can't get passed. And that's essentially the leverage point. So what's happening right now are people are trying to really do everything they can to bridge these two variables to figure out a solution that will get enough support from either the tech side or the life sciences side to get 41 or 39 people to hate the bill. If we only have 39 people that hate the bill, it'll pass. Why? If this Senate bill goes to the floor of the Senate, this may be shocking to you, especially our academic friends who want more congressional guidance to the patent system. They don't have the first clue what the patent bill is doing. All they know is that a bunch of people said, vote yes when it's on the floor. And you only need 51 when it's on the floor to say yes to make it the law. So that dynamic right now is very interesting to watch. Every kind of running on a time clock to get it done before the presidential politics just wipes out the ability of politicians to talk about things. And so you're basically running to a cliff where if it's done and a deal is cut, it'll pass and it'll probably sail through and it'll just bounce through the Senate and bounce through the House and then become law. If it doesn't pass, we start over again. And in 2011, you'll do this again. Sorry to be cynical about it. I just, gestation period for patent bills in my personal experience is 7 to 9 years. And we're only like 5 years out so far. So it's not shocking if it doesn't pass. It'll not pass immediately when Congress reconvenes. Patent bills rarely deliver votes, and they certainly don't deliver votes, months ahead of the next election. So you're not going to see patent bill kind of rapidly go to the floor after a new administration or a new Congress sets. It'll be the same kind of a process, several years, screaming and yelling, and then some horrible thing will pop out and get enacted as law. So, on that optimistic note, I'll stop. Thank you.
We have Andrew Spence next.
Well, I think Bruce and Jeff did a really good job kind of laying out the legislative efforts that are going on as far as patent reform. So I'm going to kind of switch gears a little bit and talk some about the efforts on the part of the USPTO. Cindy and I are I'm going to go over basically kind of an overview of what the rules are and give you a little bit of the viewpoint of the electronics, computer software, the EECS technologies standpoint or view on at least a portion of these rules. And then I think Cindy's planning on giving you a little bit more on the biopharma aspect of the rules. Basically, the new rules, as has kind of been alluded to, were proposed last August, set to go into effect November 1st. On October 31st, as a result of a lawsuit or two lawsuits that have been filed and subsequently consolidated, the new rules were enjoined pending the outcome of that lawsuit. So right now, lawsuits or the rules have been published, but their ultimate adoption is a little up in the air. Although I think it's important to note that ultimately, I'm sure some portion or some variation of some of these rules will probably ultimately be adopted. There are three aspects of the new rules that I'm going to discuss. One is with respect to continued examination filings. The second is with respect to the examination of claims. And the third, probably least important in terms of the different industries' viewpoint, is on applications with patentably indistinct claims. As far as continued examination filings, just kind of to take a step back a bit, once an initial application has been filed, there is an opportunity for continued examination or examination of the subject matter of that application by virtue of not only that first application, but also by virtue of continuation applications which actually claim subject matter disclosed in the original application, continuations in part which claim subject matter, bless you, not only disclosed and claimed, or not only disclosed in the original application, but also include additional subject matter, as well as divisional applications, which historically have been filed as the result of a restriction requirement on the part of the Patent Office to say that basically you either have two inventions or two separately usable inventions that are claimed and will require you to essentially pursue one, and if you want to pursue the others, file those by way of divisional. The proposed rules set forth a limitation, or rather a restriction, on the number of continuation applications, including continuations in part that may be filed, limiting those to two without a successful petition to the Patent Office explaining why the third and so forth application could not have been filed, or the subject matter claimed could not have been presented before then. In addition to that, I actually need to back up a little bit. There is an avenue in the Patent Office. The notion that the final office action is a bit of a misnomer is true in the fact that, once you receive a final office action, you can continue to prosecute the application by virtue of a request for continued examination, in which case you pay the Patent Office a fee and essentially start with a non-final examination on the part of the examiner. The two continuation limitation or restriction would also add a restriction to one request for continued examination. So ultimately, in a patent family, you would be entitled to two continuing applications and one RCE. That does not apply to divisional applications, which are considered a separate invention. So for a divisional application, you are equally entitled to two continuations and one RCE. Speaking a little bit on the retroactivity of the proposed rules, they did apply the new rules or set forth application of the new rules to families that were already pending, but did allow for a quote-unquote one more application in those so that people weren't necessarily precluded from filing any more or were kind of cut off once the new rules came into effect. A couple final notes with respect to continuing examination filings. With respect to continuations in part, the theory behind a continuation in part is that you have some claim subject matter that is entitled to the benefit of the filing date of your parent application, but that you have some claim subject matter that is not. The new rules would place an affirmative duty on the part of applicants to identify to the Patent Office which of those claims would go back to the parent and which of those claims would only be entitled to the new filing date of the continuation of part, the new subject matter, if you will. And lastly, with respect to divisional applications, previously applicants were allowed to file what I'll call, or what have been called, voluntary divisionals, in the sense that they did not actually have to have been restricted by the Patent Office. The new rules changed this and essentially would require any divisional to have been the product of a restriction and an election on the part of the applicant. Basically doing away with voluntary divisionals, or in turn roping those in with continuation applications. The second part of the new rules is with respect to examination of claims, in which the new rules set forth a restriction on the number of claims that may be filed without additional what they call examination support documentation on the part of the applicant. They allow a 5 independent claim and 25 total claim limit, far fewer than the RIM number of patents in the hundreds. Any number of claims in excess of that require on the part of the applicant what's called an examination support document, which is in essence the applicant submitting documentation, or essentially going through the exercise of performing the functions of the examiner before and at a first office action, and the functions of the applicant in response thereto. Applicants would essentially be forced to conduct a prior art search and analysis of the prior art and explain why their claims are patentable over that. And all of that would be essentially submitted to the office prior to a first office action. The last part, which I'll kind of skim very quickly, hopefully get us a little bit more caught up to speed, is with respect to patentably indistinct claims. As it stands right now, you can have applications that, although they describe and claim similar subject matter, aren't formally related to one another in a chain, in the sense that two applications can be by the same inventors, describe similar but different subject matter, be filed concurrently or within a short time of one another, and essentially follow two separate paths of the Patent Office. The proposed rules would actually require applicants upfront to identify to the Patent Office each of those applications, and in turn, if they relate back to patents, those patents. And for some of those applications, regarding applications that have concurrent filing dates, may create a rebuttable presumption that the claims are patently indistinct from one another, and in certain instances may require consolidation of the applications on the part of the applicant. Turning a little bit now to the EECS technology viewpoint on these new rules, the primary argument, or the primary point of contention, I think, between the different industries is with respect to the limits on continuing applications. In the electronics industry, it's fairly typical for technology to be, and I'm going to actually discount the Lemelsons and the quote-unquote those who invent patents, and talk more in terms of traditional companies who actually do research and development and produce products. In the EECS field, those products are usually fairly developed by the time an application is filed. It's not uncommon to have an application filed and even rushed a little bit to try to beat a product launch. So from that standpoint, it's fairly readily known to the applicant at the time that they file an application what their invention is and what they believe will give them the most commercial value. The flip side of that is, traditionally in the EECS fields, technology has a relatively short lifespan before it becomes obsolete or is replaced by newer technology. Prime example would be Apple's iPod. I don't know how many of you are familiar enough with the iPod, but if you looked at some of the more original iPods compared to the ones that are touchscreen based and so forth now, and the short period of time in which that evolution took place, you can see how in the span of 5 years, some technology that may have been critical to a company up front is now all of a sudden less important, if not obsolete. And for those two reasons, the the EECS technology sector is fairly interested in trying to speed up the examination process at the Patent Office. My personal experience with this is, going sometimes 3, 4, 5 years from the time an application is filed until you receive a first office action from the Patent Office. If you couple that with a year, sometimes even more, of examination before the application is actually allowed, and it's not out of the realm of possibility that by the time this application is allowed and issues into a patent, that your technology is no longer as commercially beneficial to you as it was when you originally filed the application. The second viewpoint, or the second area of interest to the EECS group, is with respect to different terminology, but I'll call them patent trolls just because it seems to be the term that most people are familiar with. Those who file applications on typically broad-based subject matter, but purposely allow those applications to remain pending in the Patent Office, whether by delaying allowance of that patent, of that application into a patent, or by virtue of continuing to file continuation applications to further hone the claims into what may have emerged by a competitor, or even by somebody, even by another big company that may be a target into their particular product. It's not uncommon to see issued patents that may have been originally prepared and filed directed to one technology, all of a sudden being asserted against an entirely different technology base, not from that original disclosure and those original claims, original disclosures yes, but original claims no, but based on a third or fourth continuation in which the claims no longer resemble what the applicant had asserted was the benefit and the advance of their invention, but now are more directed to what may have later been developed, or what may have later been found to be commercially beneficial. And for those two reasons, the EECS group, I think, is more primarily concerned with the timing of application filing to issuance and how it would affect their prosecution in front of the Patent Office, as well as with trying to curtail this not uncommon but not prevalent, I don't think, practice of having a large number of continuing applications filed. And as an aside, it's not, I don't know, it's not it's worth noting that the new rules as they're proposed, based on my current practice of preparing and prosecuting patents in the EECS group, just doesn't have that much of a significant negative impact. Rarely do in my own practice, or do I see a lot of companies in the EECS field filing a lot of continuations, particularly companies who are doing, as I said, research and development and coming up with products. And ever since the Patent Office 2 or 3 years ago significantly increased the fees for excess claims, do we file a lot of applications that have a significant number of claims, just because the cost benefit up front is just not worth it. I had planned on going a little bit into some practitioner, I think, important aspects that had been, that I think were underscored by the new rules, whether they come into effect or not, but for time purposes, I'll leave that short and just, I think they're going to be publishing a paper in the technology.
Right, and we'll certainly, you've been very kind to try to limit yourself. We can certainly give you time in the question and answer session to go into some of that.
Okay, and to just let you know, that there are, as I said, there are some, I think, I'll call them practitioner tips, or more tenets, I think, that are underscored by the new rules that I think, even if they didn't come into effect, warrant some thinking on the part of practitioners when you're actually going through the process, whether you are under these new rules or not. And I'll leave it with that.
Thank you very much. Rothschild, and then everyone will approach for the moderator panel session.
Thank you, and thank you for giving me the opportunity to speak today. I've really enjoyed these presentations, and seems like we're going a little bit from a very high view of the new patent reform, and now talking about the patent rules that have been promulgated or proposed, by the USPTO. And I just want to pick up a little bit on that discussion regarding the new patent rules and talk a little bit how they will affect companies in the biotech and the pharmaceutical industry. And Jeff had mentioned that there are patent attorneys in the patent bar who are not too favorably inclined to look at the rules, in good regard, basically think they're kind of stupid. And one reason for that is in certain industries, it's felt that these new rules are going to make it very difficult for companies, for example, in biotech and pharmaceutical industries to get meaningful patents. So I just want to talk a little bit about that. So it's going to be kind of talking a little bit about the nature of big pharma and biotech and drug discovery, and then why, because of the nature of this industry, these new rules are going to may make it very difficult for these types of companies to get meaningful patents. As Andrew was mentioning, very often in the computer-based industry, the product is pretty well developed by the time a patent is filed. So, you've got your product in hand and you go and file a patent, and the issue is really trying to get the patent allowed before the product becomes obsolete. Now, in the pharmaceutical and biotech industry, it can be very different. And one reason for that is the long length of time that is required between drug discovery and actually getting that drug that you're interested in or that compound that you're interested in. So, for example, a company in a biotech or pharmaceutical company first will have to identify a market. They'll have to look around and see, okay, what is the disease that, is really important that we want to track here. And once that's determined, for example, Alzheimer's or, HIV, cancer, that kind of thing, the next thing to do is to identify a biological target. So that means that a fair amount of research needs to be taken to actually say, okay, we're really interested in Alzheimer's proteins. There seems to be this receptor in the brain, this nicotinic receptor or this whatever receptor, that appears to be involved in Alzheimer's disease, and to do the basic science and establish the biological target. And this can, take several years, and the cost of employing scientists to do this and that type thing. Once a biological target has been identified, for example, that receptor in the brain that you think might be linked to Alzheimer's disease, the next step is to try to figure out, okay, how are we going to modify the activity of this receptor? How are we going to develop compounds that we think might bind to this receptor? And this type of work can be done, for example, in the old days, well, not in the old days, still very often is done as wet chemistry in the lab. So it may take months to years to develop 5 or 10 or 15 prototype compounds that can be used that you think might interact with this receptor that might be good candidates for this disease. Now, very often enough is known. For example, if something's known about the receptor, you can use computer modeling techniques, and then doing that type thing, you might be able to develop, several hundred to thousands of prototype compounds that you think might actually work with this receptor. So, you have this initial stage of identifying candidate compounds. But usually, whatever level you're at, you're just identifying compounds that you think are going to be active at this receptor. So you might have anywhere from several hundred to maybe several thousand compounds. At this point, you've identified some compounds, you're really excited about them, you might do some experiments in the lab, perhaps, see if the compounds actually bind to the receptor, or see if the compounds of interest, or at least some of them, might inhibit this viral protein that you think is important for AIDS, or, inhibit cancer development in some types of cells. And if you find that they do, then this may be the point at which the company is going to go ahead and first file its, like a provisional patent application. So at this point, the company knows, well, we've got several hundred compounds that we think look interesting. We've tested, 20 of them, and this is after about, 2 or 3 years of research. I think we have enough. Let's go ahead and file a provisional patent application. So, as I'm sure we know, you file the provisional and you sort of start the clock. So you have a year now to gather more data to see if you want to go ahead and file a utility patent application. So, over the course of the year, the company is going to be able to, perhaps evaluate, instead of 3 or 4 compounds, maybe evaluate several hundred compounds in some additional test tube in vitro type experiments. Does it bind to the receptor or inhibit the protein? So 1 year after all this research goes by, perhaps with a science team of, 5 to 10 individuals, there will be enough data will be accumulated to file a utility patent application. So at this point, the companies will most likely feel very strong, have some good, strong data that at least some of these compounds are binding to the correct receptor, and there's an indication, at least because they know what this receptor does, that it might be, for example, a good compound to treat AIDS. That's usually at the point where many companies might file their utility application. So now the application's on file. So the company may not still know which candidate, it may be describing, have claims for that can cover thousands of compounds, and then several claims that might cover several hundred. These are called genus claims. And then there may be, 5 or 10 specific species that look really like they're working very well in the lab, and so we're going to have some claims on that. At this point, the company will probably start going in and do some significant animal testing and really start to narrow in on which of these compounds are the important ones. So, you're still at the point, you filed your patent application, you have maybe 1 or 2 candidate compounds that are going to be, the ones you're going after, but the company still doesn't have anything yet to go to market. Because at this point now, we'll have to go into our phase, 0 through 4 clinical trials. And just to kind of give you a sense of what's involved in that, very often we'll start with phase 0 clinical trials. And in these types of trials, these are very small clinical trials where a few individuals that have the syndrome might be tested in terms of some type of small dosing studies or toxicity studies, just to be sure that there's nothing really, real problems with the compound. Next, the company will engage in phase 1 clinical trials, and these are really a little bit larger number of patients, again, evaluated for toxicity, pharmacokinetic type data, and pharmacodynamic type data, just to be sure that there's no real problems with, for example, at this point, maybe 1 candidate compound and a couple other sub-candidate compounds. Next, the company will undergo phase 2 clinical trials, and this is where, the company is going to now start testing that candidate that it thinks is the one that's going to work in real patients, and see, okay, number 1, does it work? Are there toxicity problems? Are there any other problems? And this is very often the point at which certain, drugs will fail, and the company is just going to have to go ahead and just forego the whole set of experiments. But just to give you a sense, these kinds of trials can cost anywhere from $15,000 to $25,000 per patient. So you get a sense now, and this is usually going to start occurring about 1 to 2 years, or into the patent filing, while the patent application is sitting in the patent office. Meanwhile, at this point, the patent is starting to be examined, and you may have claims in there that cover several compounds, but you do have claims for the compounds of interest. So it's all kind of 2 things are occurring at once. And the patent is being examined, and yet the company is still trying to get substantial data to show that their compound of interest is, number 1, going to work, and number 2, to get data to get it approved by regulatory authorities such as the FDA and that type thing. And then the final phase of drug testing is phase 4 testing, which phase 3 will be a larger population, I think I just mentioned, where you're testing to be sure that the compound actually works. And then phase 4 is long-term testing to be sure that there's no long-term toxic effects. While all this additional research is going on, the company may find out, additional aspects about the compounds that is disclosed in the patent application. Also, there may be a need to do research to determine how to formulate the compound. As Jeff was saying, you may have a compound that in one case can be administered as a saline solution, or you may need to add a salt to it. And that salt may be crucial to getting the bioavailability that's needed for the compound. These kinds of developments is sort of like an ongoing stream of research and development are very often hard to tease away from the initial amount of research that went into developing the compound in the first place. So very often, companies are interested in filing additional applications on these additional developments. And these are the types of applications that very often the pharmaceutical companies or biotech companies will want to file as a continuation in part. You've got a compound that you described in your initial application. You said it might be good for Alzheimer's, but you also thought, well, it might also be good for controlling seizures. As your research develops, you realize, oh yeah, compound 394 of our initial list of 5,000 compounds really is great for controlling seizures, and we'd like to protect that, that disclosure and get credit for all the work and research that's gone into that. So for those reasons, in the pharmaceutical industry, you very often will have not only your initial filing, but you'll have multiple continuation filings on additional drugs, perhaps or compounds that were disclosed in the original application, formulations that you've developed, or additional data that is included in these applications. So I just wanted to kind of paint a picture of how, because this type of work and this kind of development in that industry is so long-term in nature, it's difficult. You want to file early to protect your IP, and yet you need time to develop and really do all the safety testing that's required so that you can get patentable claims that are worthwhile. I just wanted to, I know we're behind, just wanted to take a few minutes to talk a little bit about why the new rules are so unpopular among these types of industries and patent practitioners like myself who represent these kinds of clients. One of the new rules Andrew was telling us about was that there's the Patent Office wants to limit the number of continuation applications and continuation in part applications that can be filed based on your original application. Well, if you just think of continuation in part applications and that scenario that I just kind of broadly described, as you're looking not only at your data and you're developing additional data, finding new compounds, finding better ways to administer these compounds, that data, as it's ongoing, you may want to, include that in and file additional patent applications. And one way that a pharmaceutical company often, or biotech, will do that is add that data to the initial application. You'll get the first priority for the original data, and then you get the later filing date for the new data. And the reason, although it would be great to file a brand new patent application with your new data and just start prosecution there and have a clean break, very often it's hard to tease away the initial research from the subsequent research. For example, you initial have research that you can administer this compound as one type of salt, but then your later research and development lets you discover that actually, no, there's the 34th salt that we tried is really the best one, and this is the one that we want to market, and it's going to really help people when they take this drug. So that's the kind of thing where you want to be able to file a continuation in part. And by limiting the number of continuation in part applications, really the Patent Office is limiting the amount of discoveries that these companies are able to receive patent protection for. It's very hard to know when you first go on this, you first start your initial research where it's going to lead you. There's just no way to know. Every compound is different, every disease is different, and you just don't know which way it's going to go. So very often you need that flexibility to be able to file additional continuation patent applications on what may be a very important technology. Similarly, limiting the number of continuation applications. A continuation application is where you just take the original application and whatever was in it, but you decide that, well, we had claims for, compound 37 as specifically treating Alzheimer's, but we also described that some of the compounds might be good to treat epilepsy. And now we found that, we want to pursue these additional compounds to treat epilepsy. So we file a continuation application, which includes that original disclosure, but may have claims for different aspects of the invention. And again, by limiting the number of continuation applications, it can be argued that the Patent Office is limiting the ability of applicants to further describe and get further patents on their discoveries. The Patent Office also wants to propose rules to limit the number of requests for continued examination. And a request for continued examination is where you're trying to get your patent through the Patent Office and the examiner and you are going back and forth haggling about art or the claim language or whatever, and you only get two chances to do that, and then you have to file a request to have your application examination continued. So it's a request for continued examination. Well, I think going back and forth with the examiner is a good thing, because what happens is the examiner finds art that you don't know about, or the examiner finds, everyone wants to write a perfect application, but sometimes you don't. So the examiner finds a better way to phrase your claim, and you go back and forth, and what your client and, the company ends up with, I think, is a stronger patent. You've got your claims, they're distinguished over the prior art, maybe art you didn't know was out there, but, you end up with a stronger patent. By limiting that back and forth, I think what's going to happen is practitioners are going to have to say, okay, well, let's just take the narrow claim for this one species. We're not going to really be able to go and try to fight for maybe a broader claim that, really the client deserves, because they have developed something that's broader and patentable over the prior art. I think additionally, by limiting the number of claims, that can be very difficult in a pharmaceutical type patent where you have a complicated technology, and very often you do want to have claims not only for the compound or a genus of compounds, but you might want claims for a method of treatment. And you might want claims for, well, how they made this compound. I mean, it might be an invention that the chemistry that went beyond, that went into making the compound is an invention. Or even the invention of how to formulate the compound. It may seem trivial whether you're going to add a salt or a buffer or this or that, but actually that can be a very important part of the final product. So all these, it's important that it's one thing to request increased fees for examiners having to examine all these claims, but it seems that, again, to limit the number of claims that can be examined can be harsh in some cases. There's one more set of rules, and then I'll wrap up, that have been proposed by the Patent Office, and that is regarding information disclosure statements. And as a patent practitioner, and anyone that files a patent is required to submit references related to the patentability of the invention. And the new rules would require an explanation for any references, if there were more than 20 references, or if the references are more than 25 pages long. Well, as you can imagine, in this long, involved procedure of drug discovery or whatever, very often there are more than 20 references that are relevant to the patentability. So, it's already quite a burden to gather your references and, and make sure you've got them all and file them with the Patent Office, and then to have to go and characterize each reference and why it's relevant to a claim. Again, it can bring up all sorts of issues in terms of a practitioner trying to advocate for your client, and yet you have to, submit references that are relevant to the invention and point out exactly in which claim this reference is relevant. It can be very difficult. So I think with that, I'll wrap it up so we can have time for our discussion. Thank you very much.
Presenters, as well as Professor Thomas, could approach. We have, all right, we have about an hour. If you can keep your appetite in check. We're going to go till about 12:50 just because we're running a little bit behind and we want to have plenty of time for discussion. I will start out with a few questions, and then we will open the floor to the audience.
Shouldn't you be sitting there? Troublemaker.
And I suppose if everyone is very hungry, you can refrain from asking questions, and we'd be done by 12:30, but that's up to you. So you can select your own time frame. So I have one question regarding this question of continuations, because we saw a very distinct perspective from the, broadly speaking, the IT sector versus the pharmaceutical sector, which is the following, that it would appear that an approach which basically increased fees for each continuation that was filed might end up being suitable for both industries, because basically the trolls and the other entities that are using continuations for bad faith purposes would probably not be inclined to pay those extremely large fees. Whereas for the pharmaceutical sector, they may be so inclined because their patents are so important, and those large fees would also create, force everyone to do a cost-benefit analysis on how, in terms of the costs that they're imposing upon the system by continually filing versus the benefit that they're getting. Whereas under the current system, the fees don't seem to require that sort of cost-benefit analysis. So I'm wondering, actually for all the panelists, whether a system of increased fees that took into account the costs imposed upon the Patent Office by repeated continuations might end up self-selecting and taking out the trolls, but leaving in folks who needed the continuations for whatever reason.
Well, I think increased fees actually do help. As I said when I spoke, the Patent Office a few years ago significantly increased the fees that were due for excess claims, in addition to the ones that you were allotted because of the filing fee. And those alone cut down on the number of claims that I was filing in applications, because the cost-benefit analysis didn't come out in favor of filing those. My only, caution or concern with the increased fees is, there are a lot of the patent trolls that are, what I'll say, honing in on certain targets, that by the time these continuations come about, they know the commercial value of these inventions, and in those instances, I don't think cost is an issue for them.
I see. So their hold-up profits are sufficiently large that they'd be willing to file those additional continuations.
Right.
Yeah.
Once they, I'll say, identified a particular industry that's kind of started to roll into the territory of where they're already filing, I think the concern for the increased fees is less so than it is when it's a little bit more speculatory in terms of where something might go.
Anyone else want to comment on that?
I actually think increased fees is a good option and a viable alternative, because, as you say, there are companies or people who will just file a continuation really just to keep the application pending in case, they're sued or whatnot. So, and that, it is a burden on the Patent Office, and there doesn't need to be something done to try to get things to work better. But certainly, I think increased fees would, allow for the hiring of more examiners and, solve a lot of problems along that line.
Well, it's interesting that you agree with that proposition, because one of the things that also occurred to me, and I was thinking about this in the context of your describing the situation where a genus application is filed initially, and then, you're trying to figure out exactly which species of that genus is going to be the drug that actually works. Rather than having, if you had increased fees for continuations, wouldn't be very different from a situation where you initially just filed on each species? Because I assume the reason you file one genus and then try for continuations is that's cheaper than filing for each species initially. Or is that not correct?
sometimes, the other thing is, you know, you may feel that you've invented a genus, and so you want to file on the genus, but there may be art out there that you don't know about. And so what you also want to do is then have a subgenus, which is a more narrow claim, and that way you might not get invalidated by that art, and then specific species claims. So,
And you think that initially filing for, just breaking up your genus claim would be more problematic than for purposes of prior art?
well, sometimes
Well-
if you can get the genus, you can
Well-
get everything.
I mean, there is a effect of the fee tied to the claim, but one of the problems is if we could figure out which of these 10,000 molecules was the one that was going to get to market, we wouldn't be patent lawyers. You know,
Right.
So the challenge is you need to have a little bit of a flex in that system. And the genus, I mean, as a genus is a supportable concept under the patent law to, if you've got enough of a support, you know, for the common elements that define the genus. And that's compatible with this pattern that Cynthia was describing of you kind of focus on the receptor and the activity and the class of behavior of the molecules, and then you home in on the candidates that you're going to survive safety issues and potency
Right.
issues. But, I mean, and I'll throw my voice in favor of, you know, fee escalation is certainly a component of the solution. It has to be, and I think you just have to have a realistic perspective. If you're talking about a funded troll who makes $500 million a year in licensing fees and has no operational costs, you know, they'll spend $10 million in fees for the opportunity in the future. And you may see impacts hitting a lot of real companies by that escalating fee structure. I think it's appropriate, though. And the only other asterisk I would put on is, you know, and I think I'm the only ex-patent examiner in the room, so I can say this, but, you know, not every patent examiner is reasonable and balanced and judicious, and sometimes, you know, their opinions aren't perfect. And so it's not always, you know, the PTO is always right, and we're just doing this to irritate them. You need to have a little bit of realism in how many times you have to go back and how to reconsider things that they do. So.
And I'll ask just one final question, because I've become a little bit obsessed with this continuation stuff. Obviously, one of the reasons you want to do continuations is rather than just filing a new application, you usually get the initial priority date. But of course, now, with 20 years from filing, you're losing patent time by doing the continuation as opposed to filing a new application. And one of the complaints you hear from pharmaceutical companies is that they don't have enough time on their patent life by the time the drug gets to market. So aren't you losing patent time by using continuations rather than filing a new application?
Yes.
And is that something that you consider?
Yes, it is, and, you know, and it just shows for some industries, the nature, you know, of the technology is just that's just the thing you have to do. I mean, you just really don't have a choice sometimes. And that's why it would be better practice if you could to, you know, start with a fresh application and not have to claim priority back as a continuation in part. But very often, it's hard to say, well, you know, that first application's published, and quite a bit of that, you know, this material's in there, you know, and you may not feel comfortable doing that, so you forego patent term.
Plus 5 years of valid patent life is worth a lot more than 0 years or 5 years of invalid patent life.
Right, if you have prior art that comes up during
Right.
that interim, right, yeah. All right, well, I have sort of honed in on this continuation stuff, which probably is only of limited interest to at least some of the audience, so I'd like to open it up to the audience to talk more generally about patent reform questions and for any of the panelists, all of whom I'm sure have lots of opinions. We will start with a student, because this is, after all, a student-run symposium. Pamela, excuse me.
I wanted to ask a little bit about the relevancy report and the prior art search requirement, because I don't see how that helps anybody except people who want to use inequitable conduct to break patents later. It seems like for practitioners, to me, it's very scary. It's just a hornet's nest waiting to happen. So I guess I wanted to hear from you guys, what's the good of it?
I would call it evidence.
I hate to put myself in the old person's category, but I'll do that. In the 70s and in the early 80s, practitioners did, with every reference they disclosed, include brief explanation of why it was relevant. And when I was first starting out, my mentor explained to me how you draft this. He said, you need to write at least a couple of sentences, and please be sure you don't say anything. Because of the fear of mischaracterizing the reference and then someone coming back and saying, how dare you? I think an example of how this can go awry is, and Jay and I were talking about this last night, it's Samsung and I forget, SEC, I think Semiconductor, get the name of the company, a case from the Federal Circuit, where I think in good faith they took a Japanese reference, I believe it was Japanese, but a foreign language reference, and submitted the translated portion of it that they thought was relevant. And that was their undoing, because during the trial, oh no, it's the other part that was really relevant, and you hid that from the examiner. Well, they handed over what they thought was important. And I see the same problem when you have the relevancy statement. I think this is the most important part. This is the part I'm going to direct the examiner to. But at trial, you know that that part that you didn't talk about is going to be described as the most important, and how dare you have not explained in great detail to the examiner why that was so important. The theory behind we're not going to have that reporting requirement anymore from the early 80s was submit the reference to the examiner and let her read it. Let her decide what's important. You're not holding anything back, and you're not misdirecting the examiner intentionally or otherwise. So hornet's nest, you bet. Tried once before, you bet. Dropped, you bet.
Since you raised that, I actually had to read some of those when I first started the patent office.
My
I can
apologies for the ones I wrote.
confirm, absolutely meaningless. You did a good job.
Okay, well, I'll take a different view. I've got to break the grip of unanimity on the panel. I think on a couple points. The patent acquisition system can't continue as it is today. Right now, pendency is looming larger. The USPTO is under extreme challenge, and it's looking around for assistance. Garbage in, garbage out. Now, we've heard on the panel that Congress doesn't know what it's doing, the USPTO doesn't know what it's doing. Well, you must know what you're doing then. Someone must know what he's doing. And so why don't you tell the examiner? It's amazing to me as a special master or someone who reads patents, how many files are put toward the office without even an IDS, which suggests to me, boy, what a great inventor. She came up with this totally on her own as an epiphany. There's no background whatsoever. She had no knowledge of anything in the art and just managed to file this on her own as just a bolt out of the blue. Obviously, that's a problem, and that's not something that I think is appropriately wrought. So I think that the Patent Office could indeed benefit. Who is going to know the art better, the applicant or the examiner? I wasn't an examiner, but I taught at the USPTO Academy for many years. At one point, I taught almost a third of the examining corps. And I can assure you that the inventors themselves know the art much better in virtually every case than the examiners. So I think if we want better quality patents, we need to be serious about it and make those kinds of investments. Now, I'm disturbed to hear, and hope would not be the practice, that members of the bar would in fact ignore their obligations to the government when they file these forms. And if they do so, I think then the Patent Office needs to be more aggressive about ensuring obligations are met. Now that makes, again, I've heard naive, doesn't know what he's talking about. Well, again, if you know what you're doing, I just think it's a garbage in, garbage out situation. So I think we need much better disclosures to the office. And we're in a world right now where there aren't as many IDSs filed as need be. I would strongly encourage.
Or too many in my world.
Okay, I would strongly
two different
encourage
problems.
This reform, and I believe it will advance quickly.
First of all, I have no explanation for the inventor who says, I know of no prior art whatsoever. That seems odd to me, and it also seems to me that if in fact they know about prior art and it is material and they are intentionally withholding it, the inequitable conduct sanction and I appreciate the argument as to how severe it ought to be, but that's the sort of situation where I think you want a severe sanction. You had material art, you intentionally withheld it, bad news about that patent of yours. It's unenforceable. Too bad. Don't do that next time. But underlying this notion that I don't think it's that the PTO doesn't know what it's doing. I think the examining corps is a pretty bright group. I mean, we all know this. One of the things of living in Washington, you're bound to know an examiner. or 2 or 20. And they are very bright people. And I think to the extent that the examination process is not working the way it should, I look more to those people who are managing those examiners than I look to the examiners themselves. I think with sufficient time and sufficient number of examiners, and training them and bringing them up to speed is a tough thing to do, I think that improves patent quality more than anything else that we can do.
I don't want to dominate. I think that the basic problem that we face is finding sufficiently granular solutions to the particular problems, because kind of these one-size-fit-all solutions you find breaking up, and hitting the different industries in very different ways. The major issue we see in the biotech area is not that we're not citing any area, is that we get hit for citing too much. And that's, because we have an exaggerated risk on inequitable conduct coming in, forcing us to put everything we can conceivably think of into the record. And that's almost worse than no art, because now you have an avalanche. The sweet spot that really people should shoot for is creating the opportunity for the patent owner or for the patent applicant and the examiner to exchange an initial thought, to focus the examination and let the examiner hit them. Now, one other thing that I will point out, we tried this when I was in the PTO. We did kind of this, I don't know if you may have been around at the time, they did this trial project of a pre-examination interview, and they set it up wrong. What they did was they said, come in and tell us why your patent application has a patentable invention described in it. And so it's kind of like self-immolation. I'm going to walk into an office and I'm going to say, well, here are the major defects under the patent law of these claims I presented, but here's why I think these claims, which I haven't presented, are patentable. That's never going to happen. Nobody who's an attorney will ever do that to their client. So what I've always felt is that there needs to be some kind of an impetus forcing action by the applicant, and it may be that you set up, an initial screening group in the technology areas that don't get any information to say, all right, I read your application, send me a claim chart, or send me, the following areas of prior art, some kind of an interaction which focuses the production of a little bit of information before they make a decision. And that would be great in addressing fundamentally the problem of the examiners not understanding the invention when they issue office actions. That, I think, is a root problem, that you have this ignorant examination standard. It's not ignorant patent examiners, just that you have an assumption that's wrong at the outset, which, if it was right, would produce a much better quality patent. In our world, in the biotech sector, what we need to do is we need to have kind of an ability to come in and home in on a set of references that they really should be looking at. But by doing that, that's just suicidal under inequitable conduct. So those are the things that I focus on when I try to envision ways of making the system work better. You can process the initial information better than it is in the current system, but there needs to be some kind of evaluation of the consequences of trying to do that.
I just want one comment. I think too, for some industries it is important to disclose, but I know very often I may have an application and have 200 references to look through, to disclose. And, very often I'm surprised if I'll disclose those references, and, the examiner may see something in a reference that I didn't think of. They just may pick up on something based on what's claimed or whatever. So I think you have two problems with the new rule. One is there will be a tendency to try to reduce these references and say, well, that one's really not that relevant, and you may inadvertently leave one out, or you could mischaracterize it. You could mischaracterize reference, 80 as teaching this, where really to the examiner it teaches Y. And, that can come back as a potential inequitable conduct, which could be a problem.
Although it sounds like then the problem is the inequitable conduct doctrine, and we've got to change that, which is a separate set of issues than information disclosure per se. And it seems to me that a lot of your reactions have to do with the current inequitable conduct doctrine.
Can I ask a question?
Sure, not of me, I hope.
No, but when an inventor gives you a stack of 250 references, do you read them?
I look through them. I mean, I don't read each one. It's hard to read them all through, but you try to get the understanding of what they're about.
Is that true for everybody?
I rarely get 200 references, so.
I'm just curious.
We don't like
back
to
in
do
the day, I read
prosecution.
them. I read them back in the day, yeah.
But I think that's sort of the fundamental problem, is you don't get to look at it at the level of detail where if that patent ends up in in litigation, that you're going to suddenly unleash 10 or 20 associates to read every one of those things with that level of detail and say, whoa, did you see on page 46 in that one paragraph where it says X?
Well, and that's, I mean, the 15 references out of that 250 are what you want to hand over to the office and say, read these and you really understand why my invention is patentable and what you should be concerned about. I take the point you just made about examiners seeing things differently, because they do. I will have a bias. I will want, I think it's patentable over this. You don't want a standard that encourages you to not give that information over, because if it's even remotely a close call, you want that in front of the examiner. But
So what about the possibility, and sorry, I will just throw this out quickly. Inequitable conduct is the stick, obviously, but could we have carrots instead for inducing information disclosure? So I take it the Patent Office has tried to give expedited examination in its current approach to those who would disclose more information. Could there be better carrots than that?
Well, fee and expedited processing are little carrots, and then inequitable conduct is like a really big carrot.
Or stick, right?
Yeah,
Right.
stick.
Yeah.
I think you could devise incentives. I think you can even impose obligations, but, again, it's like you need some protective element around the communication so you can induce that and that kind of candor and facility in the examination process, but.
And it may be that you start including in the front of an information disclosure statement, a statement of what you did to find these references and how you reviewed them, so that you can, blunt any argument of intent to mislead.
I just wanted to throw
Yeah,
out,
sure.
I do think there is already a bit of a carrot in the sense that filing information disclosure statements by themselves and having consideration of those references by the examiner does give a presumption of validity
Right.
over those references. And I think it does warrant, to the extent possible, making sure that references that of are submitted, because at the end of the day, it makes your patent stronger. While at the same time balancing, of course, to some extent, I guess you can get excessive in the number of references to where the whole point of what you've submitted gets lost. But I think initially, there is a bit of a carrot already there.
Right, and the empirical data suggests that most patents that are invalidated on non-obvious grounds or prior art grounds are invalidated on the basis of new prior art. So there is that carrot, yeah. All right, yes, back there, the man with the beard. There's only one, I think, believe it or not.
Point of interest, about a year and a half ago, I believe it was, at the NAP conference, Harry Motes of the Office of Enrollment and Discipline indicated that if you submit a reference, it means you read it. He's prepared to go after people that didn't. He likes his job.
I think that gentleman back there has been up for a while, yeah.
Well, the whole economics of the prosecution process also has to be taken into consideration as well. Because, when it comes down to patent valuation, you don't know the value of that patent till many years down the road. And so if you're spending, $20,000, $25,000 on a patent application in the beginning for something that may give you a return, but it's a may of millions of dollars, but it may not, it may give you nothing, it's hard to focus a lot of effort and a lot of, it's hard to focus a lot more resources in the beginning part of the process.
Is that, in the biopharma industry, I assume that you think most of your patent applications are really, really important. I mean, I think that observation is very valid for most other industries. Is that observation valid for biopharma?
Yeah, I do,
You think so?
yes. And I think, that's one reason that in